Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, every tendency shall be heard. God save the Commonwealth of Massachusetts, Court is open, please be seated.
I was about to say good morning, good afternoon. I am Judge Milkey. To my right is Judge Massing. To my left, Judge Neyman. And together we are your panel on this special sitting today of one case. And that case is 2023 P. 549, Commonwealth versus John C. Murphy. I'm not going to give a long windup. You guys are professionals. You know the rules. I will, however, confirm that we have read the briefs and the record. We're familiar with your arguments and the facts, so to the extent possible, I would urge you both to cut to the chase. Mr. Coban, your floor is yours.
Good afternoon, Your Honors. Again, my name is Theodore Coban. I'm representing John Murphy, and we're here because Mr. Murphy has been required to wear a GPS bracelet for 3 years, and when he finally got a Feliz hearing, he got a decision that took no witnesses, took no documentary evidence, and so all the judge's findings were made on representations of counsel.
Are they required to take witnesses?
The problem with Feliz cases, as you probably know, the SJC has solicited amicus briefs in the Rodriguez case because I think they're trying to figure that out. I think that when we have a 58A hearing, we have a probation surrender hearing, and we're dealing with people's constitutional rights. We give them witnesses. We expect there to be reliable hearsay. We expect them to be represented by counsel, and we expect that there might be some limited form of cross-examination.
Where was the dispute of fact? I don't see in your brief that you take issue with any of the judge's fact findings. I understand you take issue with the judge's balancing.
Yes.
I did not see any place in your brief where you say that the judge's findings of fact were clearly erroneous.
Well, the horror of the underlying act is clearly not something that's in dispute, and we don't go there and try to ameliorate that in any sort of a way. I will say that the violations that he cites, the pretrial violations, these occurred in 2015 when he was 17 and occurred around the time of this incident. So it occurred between the ages of 17 and 21. And I think that...
But I thought it was even earlier than that. I thought it was like 2008, 2009.
I thought one was 2005 and the other, excuse me, it was 2005 and then the incident occurred in 2009. And so there was a first drunk driving case in 2005 and then there were these 3 cases in rapid succession in 2009. He was obviously a young man who was addled with alcohol and having some very serious issues. I did want to mention to the court the SJC's decision recently in the Massey case, the juvenile parole case, where there has been a lot of discussion about the development of the juvenile brain and the frontal cortex and risk-taking. And, you know, Mr. Murphy is currently now 39 years old.
So that begs 2 questions. Number one, was there an argument made to Judge Drexler about the undeveloped brain of Mr. Murphy or his age at the time? Okay, it begs another question for me, which is, was there a request before Judge Drexler or a motion for an evidentiary hearing?
No.
Okay. So then let's go back to what was before this judge right now.
May I address that question, though?
Sure, of
because
course you
the Feliz and the Roderick cases say the burden of proof is on the Commonwealth. So they have to prove the case. It's not that the defendant has to participate in that. The burden shifting on the case, I think the cases are clear that that's not supposed to happen.
Where in Feliz and Roderick does it say that that burden must be satisfied through witness testimony and through an evidentiary hearing?
I guess it's by implication. I don't know of any other proceeding where representations by a district attorney constitute a basis to make fact.
Where in your brief, I apologize, I did read it, I didn't see that you said in your brief that it was error for the judge to make these determinations without first holding an evidentiary hearing.
I might not have said it in the brief, but it still is something I think that holds true.
Can I ask about, I'm interrupting you, is that, okay. Can I ask about the, you're asking us to sort of, do you think the judge put too much emphasis on the earlier probation violations? What about the one where he drives through the exclusion zone when he's on the GPS? I couldn't quite understand what actually At that point in time, what was the violation?
Okay.
And there was no finding of violation, but what happened?
Okay, what happened was he was first put on the GPS bracelet and he drove through Newburyport in a car quickly. He got a call from the
Marblehead.
GPS people saying...
Marblehead?
Pardon me?
Marblehead?
Marblehead, excuse me.
So it wasn't the streets around the victim's mother's home, it was through Marblehead?
No, because the whole community was placed off limits from
Okay,
him.
so at the beginning, it was just stay away from Marblehead.
And so he got flagged by the GPS people, and he called in, and that was cleared up. And so they made, at that point, the adjustment to the GPS, to the zone, to be able to allow him to go on Saturdays to see his family, because he grew up in Marblehead.
So, I mean, that kind of cuts both ways. I mean, since they had not yet set up the exclusion zone around the victim's mother's house, he hasn't violated that, but it's pretty easy to stay out of Marblehead.
Yes.
It's really hard to get to Marblehead, actually.
But he did grow up in the town and his family was there. So it is easy to do that if you're willing to be banished from the community you grew up in.
But that's part of his obligation. I mean, that's, right?
Well, I guess that's another question. I mean, when I look at 265-47, it talks about an exclusionary zone that protects a victim. I mean, yes, okay. I mean, you could ban him from Massachusetts, and that would protect the victim pretty well, too. It's a question of reasonableness. Again...
But there are tools to deal with that. Before driving through it, he could have filed a motion and say, look, I have to drive through, or this is causing me to go 2 hours out of my way. You know, if I could just drive on 495 or whatever road goes through there, that is still 9 miles from her house, that would be helpful. I mean... He didn't do that.
No. I believe this was just a recreational ride with some friends going from one place to another, and he was in there momentarily.
So let me ask you this question. You cite the two most recent cases on point, Feliz and Roderick, which I assume you agree are controlling.
Yes.
Okay. The Commonwealth cites at page 13 of their brief from Roderick, 490 Mass at 681, the quote is, had the Commonwealth satisfactorily demonstrated at the motion hearing that an exclusion zone would be configured in the defendant's GPS device, the case before us would be straightforward. Why is the present case, your case, where there is an exclusion zone that is configured in the defendant's GPS device, why is this case less straightforward than Roderick? Because it doesn't protect the victim. The victim doesn't live in the exclusion zone. Well, do we know where the victim lives?
We don't. The
she
victim
just simply
doesn't
didn't
want to
want the
tell
defendant.
anyone. It is conceivable that Mr. Murphy could spend a lot of time trying to figure out where this victim is, which he does not want to do, appear on her doorstep, and the GPS monitor would not go off. He could appear at her workplace, and it wouldn't go off because it's not configured that way. If it were different, and we knew what the victim's home was, then certainly that would be a different case than what we have. But we don't know how often she goes there. Her parents live there. She doesn't live there. That's clear from the record of the case. And
Can I just jump in, because for one, I'm confused. Because there seem to be two separate issues. One is the condition that he's excluded from a particular area in Marblehead, and then the way to monitor that through the GPS. And I understand that you can configure the GPS specific to the zone, but what does that mean in practice? Does that mean that it isn't otherwise tracking where he is going unless he goes into the exclusion zone?
No, the GPS is tracking him 24/7 every place he goes.
No, I understand, but is it, for example, recording that, or is it only recording or notifying somebody if he is in the exclusion zone?
My understanding is it records him constantly, but an alarm goes off if there's a GPS fence that is made around a particular area, in this case, Marblehead. And there is a organization somewhere that when his GPS anklet goes and breaks that fence, an alarm goes off, and he immediately gets an alarm saying, you have to call us and tell us where you are and what you're doing.
Okay, assuming all this to be correct, do you challenge the exclusion zone, or merely the wearing of the GPS to monitor his compliance with the exclusion zone?
I challenge the exclusion zone because I think it doesn't protect the victim. It's an arbitrary exclusion zone. I do notice that again, in the case that the Rodriguez case at the SJC, the exclusion zone is the entire town of Framingham and the entire town of Marlborough. We acknowledge that it's a constitutional violation to put the bracelet on someone if there's no justification for that. And I would just argue, and again, it's a matter of policy, that if you're going to violate someone's constitutional rights, you want to do that as minimally as possible.
No, I understand that, but to me at least, the focus of the court in Roderick is the 24/7 monitoring of someone's whereabouts, which is different than the mere fact of saying he can't go specifically here. Because
The Roderick court certainly is concerned. I mean, that's the search and seizure violation, to just follow him around electronically 24/7.
But the actual exclusion is not problematic. It's the monitoring of his compliance with that exclusion.
As long as the exclusion has something to do to protect with the victim. 265-47 specifically says to make an exclusionary zone to protect a child where an alarm will go off. And we don't have that here. We have people who were not affected, well, not directly affected by the offense. Obviously, the family is concerned and damaged by having to suffer through the experience. But we don't know how often the victim goes to her parents' house.
So I'm confused. It seems to me like if you won this appeal and we said no GPS monitoring, there would still be an exclusion zone.
Yeah, sure. I mean, he's not allowed to go anywhere near the victim. There would not be an exclusion zone.
It would still be Marblehead, and it would still be the victim's mother's house.
It might be, although it'd be no way to monitor it. I think the order is to stay so many feet away from the victim, which is much more effective to the victim than a GPS monitor that doesn't go off if he's standing on her doorstep at her residence.
Was there an exclusion zone in Roderick? I'm under the impression there was not.
I don't think they could formulate one in
Right, they
Roderick.
couldn't.
The woman was transient, and after a while, it did. They just couldn't put together. So Roderick is almost a very similar case. I mean, you also notice, Lisa, in our decision that the hearing judge talks about Feliz all the time. Roderick was decided months before Feliz, and the hearing judge keeps saying, well, this is a contact offense. This is a contact offense. Roderick was a contact offense. It's almost the same exact thing, although it was an adult, older person than the 14-year-old in our case.
But unlike here, where it involves someone who had a connection to Marblehead, whose parents still live there and she still visits them, that much we know. In Roderick, it involves someone who was transient, largely, I think, lived in Connecticut and came up to stay at the defendant's home in Massachusetts. That's where the offense occurred.
Yeah.
So the concerns at issue here were not present in Roderick in that respect.
I suppose if the ruling of the court is that an exclusion zone can be prepared to be created at a place where the victim goes at some undetermined time, at some indeterminate frequency, and not at her residence, her work, her school, where she goes frequently, then I guess I lose this argument.
But we certainly haven't, just to be clear, I mean, I have to put your arguments, we have to put your arguments to the test. We have not made up our minds.
I understand that, Your Honor, I understand that. But it makes no sense to me to not protect the victim. I mean, if you want to have an exclusionary zone, I mean, the victim is protected by the keep-away order from the probation department, but that is not monitored by GPS. And that will continue to be in place even if the GPS monitor is eliminated.
At the hearing, Judge Drexler said he invited you to come back like in a year.
Yes.
And have you gone back?
He invited us in June of 2004, and we're now in April. So in a couple of months we can go back.
Okay. And have there been any violations of probation since the hearing?
Absolutely none. Absolutely none. And again, I think if the judge would have accepted the letters that were offered to him,
Well, actually, so the letter from a licensed mental health counselor, is that what you're talking about?
yes.
Was that in the record? Did the judge refuse it? Was it mailed to the judge? What's the status of that?
This case was very unusual. Out of the box, the judge listens to the prosecution and basically makes up his decision. And defense counsel has to say, Judge, would you mind greatly if I tried to put in my case?
Well, there were two motions before the judge, in fairness.
Well, there was the one
So-
about being able to be with his own 16-year-old family. And so there was that. But at that point in time, the attorney tried to put in two documents. One, as a condition of his probation, he has to go through counseling. He's got sex offender treatment counseling. I don't know if it's every once a week or how much it is, but he's been doing that. And they had these letters, which I have not seen, but I presume mean he's been doing a good job, because otherwise he would have been violated on probation. The other one was a letter they've described as a risk assessment, which I think is a risk assessment for his possibility of being a recidivist. And that was not considered, and that's one of the balancing factors. So the judge, if we have scales
I
of
apologize
justice.
for interrupting. How do we know, and your time's up, but I want you to answer this question. How do we know the judge didn't consider it?
He rejected it. He said in the record, oh, this isn't from a psychiatrist.
I know I saw him say that. Did they attempt to move it into evidence, and he said no?
No, they did not. No, the attorney representing Mr. Murphy did not do that.
And so that,
Oh, go ahead.
so that's not part of the record that we have. We can't review that.
I
We don't even have the record of, we don't actually have the terms of his probation in this record that I could tell.
Well, that is the problem. I mean, the Commonwealth has the burden of proof, and there was no documents, no anything put into the record, and then there was a decision made on representations of counsel.
To the extent, and this is pure hypothetical, that we were to agree that a remand is appropriate, how would the hearing on remand differ, if at all, from whatever hearing you're entitled to in June?
It probably wouldn't be any different. I mean, unless you made a ruling about what an appropriate exclusionary zone was. I mean, again, I think the
You're
issue
saying
of
that
having an exclusionary zone where the victim does not reside, work, or have in school makes very little sense.
So not to put words in your mouth, you're saying that at a minimum, we could provide guidance to the judge in terms of how he or she should
And that perhaps he would
analyze the issue.
consider the tenders of Mr. Murphy's behavior since he's been released from prison in 2000.
So,
All set, thank you.
thank you very much,
Thank you for your
counsel.
kind
We will
attention.
hear from the Commonwealth.
Good afternoon. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the motion judge correctly weighed the competing interests and determined that GPS monitoring was reasonable in the circumstances where the defendant had been convicted of a brutal rape of a 14-year-old, had been classified as a level 2 sex offender, and a meaningful exclusion zone had been established.
To what extent is that a question of fact, and to what extent is it a question of law? When I say it, I mean the weighing of these factors.
I think this court can accept the facts as they were presented because there's really no dispute about the underlying facts in the case. I don't think the defendant disputed them at the hearing. I don't think the defendant disputes them here before you. So we have the facts of the conviction. We have the facts of the level 2 sex offender classification. We have the potential, the dates and the years of the probation violations.
But do we know, for example, the extent to which the daughter visits her parents?
That is not in the record, Your Honor. All that is in the record with respect to the victim is that she no longer lives in Marblehead, is still fearful of the victim, does not want to disclose her current residence, but that her family still lives in Marblehead and she visits them, and she asked that the GPS condition remain in effect. So I think this court reviews those factors and the weighing de novo.
Did the judge, I'm sorry, go ahead, you can finish and then I have a question for you.
You're not bound by Judge Drexler's weighing of the factors.
Did the judge here refuse to review the report of the licensed mental health clinician?
you know, it's really hard to tell based on a piece of paper whether he took it and reviewed it and read it and simply dismissed it and discredited it and found it was lacking in weight, whether he didn't look at it at all. I wish the record was better with respect to what was physically happening in the courtroom at the time, because I think there was probably some act. He obviously looked at the document, but I think.
Was it relevant?
Sure. I think it's a totality of the circumstances analysis. It could be relevant, and it was in Judge Drexler's purview to weigh it within the weighing of the factors, and because he found that the person lacked the necessary qualifications, he did not include those findings in his decision.
To what extent, as a matter of fact, does the GPS record his whereabouts as opposed to simply whether he crossed into the exclusion zone?
Your Honors, that's not part of the record. I can represent to the court that it is, there's a department called ELMO. They run the GPS program. I think it's in other published decisions that when you have a GPS attached to your body, the ELMO is constantly recording, constantly sending GPS locations to this ELMO division of probation, but there is no trigger, there is no signal, there is no alarm on that goes to ELMO unless and until there is an exclusion zone and the defendant enters that exclusion zone. There's also an alarm for low battery, there's an alarm for low lack of signal, but I will not dispute that the GPS device on this defendant was recording his movements wherever he went within the Commonwealth. Not just when he crossed into Marblehead.
Well, putting the statute aside for the moment, at least, aren't there two separate issues in terms of could the exclusion zone be made part of the probation versus how his compliance with that is monitored?
Yes, absolutely, Your Honor. And I don't think that the defendant challenged the exclusion zone of the town of Marblehead below. The defendant it was a straight Feliz motion below. The defendant wanted the GPS removed. He did not argue that he wanted the GPS removed and the exclusion zone removed. He simply argued that he wanted the GPS removed based on the Feliz factors. I do think that if this court disagrees with Judge Drexler and finds that the GPS condition must be lifted, then the exclusion zone of the town of Marblehead, with the parameters in place that the court can see, it's not perfect, but in the docket, those would stay in place. And there's just, the only way you can monitor that is if, the defendant has a negative interaction with somebody in the town of Marblehead and the police are called and the kind of thing you see in a normal, restraining order situation.
All right.
So
In fact, you see in every restraining order violation where there's no GPS.
right. So I do think that this is, the court's decision is whether you decide to remand or not. I really think it's just focused on the attachment of the GPS to this defendant.
Is there anything in the record that suggests that the defendant is likely to retaliate or reoffend against this victim?
No, Your Honor. What's in the record with respect to his likelihood of recidivism is that he's classified as a level 2 sex offender.
It's given this horrendous crime, the fact that he's not a level 3 sex offender must indicate that the board doesn't think he's the highest level of risk.
That's absolutely true. That's fair. That's probably given his youth when he did commit the crime and the fact that he has no other appreciable record. I do not think we should discount the victim's fear of the defendant. The defendant had been in prison for so almost 20 years later. This victim is still afraid of this defendant. So I do think that is a reasonable factor that Judge Drexler included in his weighing of the calculus. And I don't think that it should be determinative that this victim did not want to give up her place of residence in order for this victim to have a safe haven. That is the case law. That's what's, and I agree, the safe haven and the exclusion zone is normally in the victim's the victim's home, and that makes eminently reasonable sense. But here, where the victim doesn't want to give up her anonymity, she should also have a safe haven. And in this case, it's her family's home, where she grew up, in the town where the crime occurred. I do think this case is controlled by Roderick, and it's slightly different because it's not the victim's.
That's my question. If this case is controlled by Roderick, tell us how this case warrants a different result than Roderick. It seems that both involve contact offenses, both
With unconscious victims.
involve serious offenses. So how is this case any different?
This offense is more serious, Your Honor, because it was committed against a child first. Second, at the hearing, the Commonwealth presented no evidence to the judge about the victim's whereabouts. They didn't have they had no contact with her, they didn't know where she lived, and the court found that significant, that at the hearing, what was before the judge, there was no possibility for a meaningful exclusion zone, despite the fact that after the hearing, there might have been a meaningful exclusion zone because they got a hold of the victim. Here, at the hearing, before Judge Drexler was able to fashion a reasonable, meaningful exclusion zone based on what he knew about the victim and about the case and about the defendant.
But say the victim, and I'm making up the hypothetical, say the victim visits her parents 6 times a year. Isn't the issue, as you've laid it out, is the added enforceability of the exclusion zone with the GPS worth the major intrusion on his liberty from wearing the GPS 24/7 the entire year?
That's not the only factor in the calculus. The Commonwealth's interests are not just in protecting the victim. The Commonwealth's interests are also in deterrence. So we also have to factor in the fact that he's a level 2 sex offender, factor in the seriousness of the underlying offense, factor in the fact that the defendant did not have a perfect record prior to trial or while on probation in this specific case, and actually did go into Marblehead. So I think it's not all or nothing. And so, and the fact that the defendant's expectation of privacy is significant, but it is diminished because he is a probationer. That's the law. So I think in these particular circumstances, in these facts, where the victim has been in touch with the Commonwealth, asserted her position, there is a meaningful exclusion zone that has ties to both the crime and the defendant. I think it was reasonable for Judge Drexler to maintain the GPS condition. And I think it would be reasonable for this court to find similarly.
Do you think that the facts are going to be any different in June?
Well, we'll have to get a hold of the victim, Your Honor. I mean, maybe the victim wants to say where she's living and is in a place where she feels confident about protecting herself and where she's living. That could be a significant difference, I think. Maybe we can't get a hold of the victim in June. I do think that the length of the defendant's successful probation is relevant. The fact that he's maintained no alarms with GPS is significant. His maturity is also significant. So I do think that there will be, and certainly if the defendant asks for an evidentiary hearing, I don't think the Commonwealth, I'm not sure what our position would be with respect to the victim, but certainly I don't think the Commonwealth has ever opposed a judge reviewing, mental health records or any sort of documentation that a defendant provides that demonstrates that he is working on rehabilitating himself.
I wanted to ask, do you agree with Attorney Coben's characterization of the probation violation in this case? So there was at that point, it wasn't a street exclusion, it was just a 24/7, 365 exclusion from Marblehead. And I found it interesting that Judge Drexler didn't violate him on that, but rather actually gave him more favorable conditions. But at that time, he violated a condition of going into Marblehead at all?
I think that's a significant factor.
That's what the violation was. The exclusion zone was Marblehead.
Right.
And he went through it.
And he went through Marblehead, right. And then they more carefully drafted the exclusion zone that actually gave the defendant permission to come in on one town.
And that was so at this same hearing, the judge reduced the exclusion zone, for lack of a better term? Is that correct?
Not at the Feliz hearing, but at a prior hearing, correct.
Yeah, at the violation hearing or the non-violation hearing, whatever.
Correct. If the court has no further questions.
No, I guess not.
Hearing none, thank you both very much. Very interesting case, well argued. That concludes our sitting today. The case is submitted, and our thanks to the court officers and the law clerks for staffing the hearing. We are adjourned.
Good job.
Thank you. You too.
Interesting.